This third session is devoted to the grant of bail to juveniles in conflict with law. And the second component of this very session would be trial as an adult under the Juvenile Justice Act. I'm so very happy to introduce Honorable Justice Jaishree Thakur, Judge, Punjab and Haryana High Court. Joined the bar in the year 1986. She was soon on the faculty, the visiting faculty of the Law Faculty, Punjab University, for 6 long years as such. Having practiced at the bar for many years as such, 28 years experience, she was elevated in the year 2014. What a blend of 28 years as a lawyer and now for the last 7 to 8 years as a judge of the High Court as such. Consequently, she brings in rich experience. She has been handling matters particularly relating to the bail to the juveniles in conflict with law. And therefore, I would urge all the participants to really draw the maximum from Honorable Justice Jaishree Thakur in this particular context. The second part would be covered by Mr. B.S. Sarah, who took the first session also in the morning. I present to you Justice Jaishree Thakur. Over to you. Thank you.
Thank you, sir. Dr. Balram Gupta, who's been my teacher as well. And I think he has been a student of my father. Correct me if I'm wrong. Anyway, welcome everyone to this session, which would pertain to bails pertaining to juveniles, whether or not bail is to be allowed to them by the JJ boards, by way of anticipatory bail, whether bail is to be allowed in matters pertaining to heinous crime, whether there was also a question that was put forth whether a juvenile would be entitled to what is called default bail, and whether a juvenile who's involved under the NDPS Act would be entitled to bail. In my opinion, the JJ Act of 2015 is a complete code in itself. For this, we can actually rely upon Section 4 of the Act, which very clearly would read out, let me get my spec, read out and say, notwithstanding anything contained in any other law for the timing in force, the provisions of this Act shall apply to all matters concerning children in need of care, protection, children in conflict with law, including apprehension. It's worthwhile to note that the word arrest is not used anywhere. Children with detention, prosecution, penalty of imprisonment, rehabilitation, social reintegration, or children in conflict with law. So having said that the JJ Act is a complete code in itself, which will take care of all the needs, how to apprehend a child once a child is apprehended, that will be dealt with in other sessions. In my opinion, and what would come forth from various judgments that I will take you through, is that a bail applied for by a child in conflict with law, the provisions of Section 12 become absolutely important. The questions that have been formulated and put forth were, let me put them out in 5 various categories. The first category would be, is a juvenile or a child in conflict with law, who incidentally, the description or the definition is as given in Section 2 itself. That means any child who's under the age of 12, I correct myself, under the age of 18, and is involved either in a serious offense or in a heinous crime. Would he apply for anticipatory bail under the JJ Act, or would he apply for anticipatory bail under the provisions of CRPC? That's the first question. The second would be whether a child in conflict with law is to be allowed bail in case he is being tried as an adult and involved in a heinous crime. And what would be the considerations while allowing bail to him? The question again would be, is the gravity of the offense to be taken into consideration while allowing or disallowing bail? The third question that has been formulated would be whether a child in conflict with law is to apply for regular bail under the JJ Act or under the provisions of the CRPC. Fourth question would be, would a child or a juvenile be entitled to default bail under the provisions of 167(2) CRPC if bail is denied to him under Section 12 of the JJ Act? And lastly, is he to be allowed bail if he is involved under the NDPS Act, considering the fact that Section 737 of the NDPS Act is very stringent, which does not allow bail until and unless the twin conditions are satisfied, which is very difficult. Now let's go to the first question, which is there. Is a child in conflict with law to be entitled to anticipatory bail? Now, what is interesting is that there are 2 divergent views that have come forth. And that too from our own High Court, so I don't have to go to any of the other High Courts. Firstly, Justice Madan, correct me if I'm, no, I think I'm right. Justice Madan, in his judgment in Krishan Kumar, minor versus State of Punjab, Haryana, has gone into the issue and has categorically held that anticipatory bail cannot be denied. That if a child in conflict with law comes forth for seeking pre-arrest bail, it cannot be denied to him. The reasoning that has been given by him is that it could certainly be not intention of the legislature that such juvenile should be first apprehended and then produced before the juvenile board, in the process denying relief to a juvenile, which if available to other persons who are accused of heinous offenses. The sentence is a bit complicated, but let me simplify it. That if any person who's involved or accused of a heinous crime, he has a right to go immediately and apply for anticipatory bail. Whether it's given to him or not is a different issue. But what is the procedure when you are apprehending a juvenile? You have to apprehend him. which in any case means almost like an arrest. You're apprehending him. The word is not used. The arrest word is not used. But you apprehend him and then produce him to before the Juvenile Justice Board within a period of 24 hours. So there's a direct conflict between these two judgments. This came to be noticed, and I think the matter now stands referred. I know the matter now stands referred to a DB in the matter of Jatin versus State of Haryana, Criminal Miscellaneous M number 17856 of 2020. The learned single judge took note of the fact of the two divergent views, whether or not anticipatory bail is to be allowed to a juvenile, and has referred it to a larger bench. And hopefully by the month of January, if not end of January, the matter should be taken up for hearing. The second question that would arise now would be, which to my mind is the dilemma which is faced by most JJ boards, JMICs, Children's Court, is whether a CCL is to be allowed bail if he's being tried as an adult and involved in a heinous crime. What would be the parameters for consideration by the board? Now, interestingly enough, while I was doing a little work, my research work, I haven't come across anything from the Supreme Court recently regarding bail and to be given under Section 12 to a CCL involved in a heinous crime. There are divergent views. Allahabad High Court, which is prolific in its judgments, is taking one view. Delhi High Court is taking different views. Madhya Pradesh High Court, I will go through that judgment and especially the last concluding portion of it. And our own High Court, Punjab and Haryana, again, which there are divergent views in our High Court itself. In reading this section, but it is always nice to go by what the letter of the law is. Now, if we were to read Section 12, the words used are shall, notwithstanding anything contained in the Code of Criminal Procedure or in any other law for the time being in force, be released on bail with or without surety. So it's almost like as if it is mandatory for the courts or the JJ boards to release a child. The question whether the gravity and the seriousness of the allegations made against the JJ, against the CCL, that is what has to be looked into. Now, if I was to take you through the various judgments that have come out of, let's say, Allahabad High Court, they are very stringent. Bail has been denied in most of the cases where there is a heinous crime involved. There, when the matter was being argued in various judgments that will come forth, they have gone on and virtually held that it would defeat the ends of justice. And for them, defeat the ends of justice has been looked into from the viewpoint of the victim and not as from the point of ends of justice relief or giving relief to the CCL. Now, if you were to on. Am I on?
Yes, please.
All right. I really don't know where the link broke, but I am going to go through and take you back to the Allahabad High Court, where they are not inclined to allow bail to a person, to a child in conflict with law who is involved in a heinous crime. Some of the judgments which I had read out earlier were Abhishek Yadav versus UP, Radhika versus state of UP, Sonu versus state of UP, Santosh, I think bail had been allowed. Now, the primary reasons where they are declining bail in these matters, which either involve 302 or sections 376 IPC read with 3 and 4 of the POCSO Act, is that merely by declaration that a person is a juvenile would not entitle him to be released on bail as a matter of right. Furthermore, they say that the statutory protection of the JJ Act is meant for minors who are innocent lawbreakers and not accused of a mature mind or who use the plea of minority as a ploy to shield themselves from the rigors of a sentence under the Indian Penal Code. Fourthly, a juvenile who is about 16 years old or a bit older than that is conscious of his criminal activities and he cannot be clubbed along with a juvenile of an age 12, 13, 14, saying it is a mistake that he committed. In the case of Radhika versus state of UP, all the bail applications that had been filed connected with that case were dismissed and they had to face their trials while they were in custody. Now, interesting is another high court, which is the Madhya Pradesh High Court. Recently, this is one of the most recent judgments. Sunil versus state of MP. Decided as recent as the 25th of June 2021. The child in conflict with law was aged 15, who had committed a rape on a minor girl aged about 10 and 11 years. Bail was denied by the High Court itself. Taking into account the gravity and the heinousness of the crime, the petitioner, though was aged only 15 years, committed an offense under section 376 upon a minor girl under the age of 10 and a half. the High Court came to the conclusion that the conduct of the petitioner itself showed that he was fully conscious about the offense that he was going to commit. And therefore denied bail. But what is interesting is the last paragraph of the judgment. And I'm going to read it slowly. You must keep in mind that the JJ Act actually came into effect because of the heinousness of the crime committed in Delhi, what we call the Nirbhaya's case. In that background, I would like to read the judgment that has been, or the observations made by the MP court after declining bail. As a parting note, this court is also at pains to observe that the legislature has still not learnt any lesson from the case of Nirbhaya, which is reported as 2017, Volume 6, SCC 1, Mukesh versus State of NCT Delhi, as the age of a child is still kept below 16 years in heinous offences under Section 15 of the Act of 2015, giving a free hand to the delinquents under the age of 16 years to commit heinous offences. Thus, apparently, despite committing a heinous offence, the petitioner would be tried as a juvenile only because he is less than 16 years old as provided under Section 15 of the Act of 2015. He doesn't get tried as an adult. Apparently, the present law to deal with such cases is totally inadequate and ill-equipped, and this court really wonders as to how many more Nirbhaya sacrifices would be required to shake the consciousness of the lawmakers of this country. Strong words, in my opinion, strong words, but need to be considered because at this age when children are have access to the internet, parents are not actually being able to control their searches on the internet. A child at the age of 15 is well aware of what he's doing or not doing. This is my personal opinion. Moving forth, actually, MP Allahabad are stringent in their giving of bails. Rajasthan High Court follows the middle path. They do give bail, they don't give bail. But look at Delhi High Court, totally divergent. They reasoning behind allowing bail to children in conflict with law, heinous offences, is that it is a beneficial legislation. The rationale for allowing the bails is that children need care and protection. The law is meant for their development and not to incarcerate them and keep them behind bars. The basic judgment that came forth from the Delhi High Court is Master Abhishek Minor versus State, where, again, a juvenile was involved with the offense. He was charged with 302 IPC, but bail was allowed to him. And this is the reasoning that was given. The purpose of the Act is to meet the need of care and protection of children and to cater to their development needs. This can be done by adopting a child-friendly approach in the adjudication and disposition of matters, in the best interest of the children and for their ultimate rehabilitation. Therefore, if there is a factor which requires the court to keep the child in custody for meeting the development needs of the child or for his rehabilitation or for his care and protection, only then it can be said that his release would defeat the ends of justice. Similarly, bail was again allowed to a minor who had committed the offense upon a 2-year-old victim. And the reasoning for giving bail in that matter was the case of Devrat minor versus state of government of NCT was the phrase would defeat the ends of justice, cannot be stretched to bring into its ambit and gravity of the offense or the interest of the victim. Meaning thereby that the Delhi High Court is following or has been following the principle of not allowing it to be influenced by the gravity and the heinousness of the crime, like I was saying, directly opposed to what the Allahabad and the MP High Courts are doing. While delivering this judgment of Devrat, the court followed Master Abhishek, the first and foremost judgment that I quoted. There are several other judgments too, where they have gone into this issue that the ends of justice has to be seen in terms of not the victim alone, but in relation to the act which has been formulated being a social legislation, and also to keep in mind how to rehabilitate a child and develop him. Now let's come to our High Court. There's a matter as far taken up for hearing as far back as 2013, which is Shimil Kumar versus State of Haryana. There, basically, when the matter came up for bail, the court remanded it back to the JJ board to see whether or not the child in conflict with law would be able to understand and determine as to what he was doing, whether he knew what was right or wrong. In the case of Master Bholu versus State of Haryana, as you all know, this was pertaining to a school student, age 16, who committed that gruesome murder on a 6-year-old child. Initially, it was the bus driver who was found guilty, who was kept in custody. But on a further investigation, they found it was the student from that school itself. Now, when this matter was being heard in the High Court, it's come up in the High Court a couple of times for bail, and eventually, and he has been tried or is being tried as an adult. The reason for declining bail was the very conduct of the child. The investigation that was conducted by CBI revealed that Bholu had made internet searches regarding poisoning, various kinds of poisons, their effects, where to buy such poison from. From the internet search, he also went into look into the issue as to how to wipe out fingerprints from the scene of the crime. And therefore, while declining bail, the Punjab and Haryana High Court held that the conduct of the child has to also be seen. Whether or not he's able to comprehend what he is doing. And therefore, that became one of the basic grounds for disallowing bail to him. Whereas, again, like I'm saying, there are distinct judgments coming out which are at variance with each other, and the reasoning and the logic is different. In our High Court too, I personally have allowed bail to children in conflict with law by keeping in mind two important factors. A, the gravity has per se not really weighed with my particular court. what I have always stressed upon is that while bail is to be given or not given is the social investigation report. The social investigation, if it is a beneficial legislation, which it is, and there are three embargoes as to why bail will not be allowed. Like I started off saying, that the words used in the section is shall. It shall allow bail subject to 3 conditions. If the child is in any moral or psychological danger, if he's released and sent back, if it would defeat the ends of justice, and the third reasoning is, the third reason for not allowing bail is that he would go back into an association with criminals, known criminals. None of the social investigation reports actually fulfill any of these conditions or say, yes, this is the background of the child. This is he doesn't go to school, he hasn't been studying, his parents are not in a position to look after him, and this is the background that he comes from. That is why in the matter of Vishwas versus State of Punjab, directions have been given that a social investigation report is a must. The High Court, our own High Court, apart from Bholu and maybe one odd other case, has by and large is allowing bail to the minor child, to the child in conflict with law. And some of the judgments are Sandeep alias Sippy, State of Punjab, 2016, Volume 3, RCR Criminal, Amritpal Singh alias Niku, Sahil versus State of Haryana. And if you were to look at these judgments, they are primarily going into the question that there's nothing available with the court on the record to deny bail to the child. They have gone into the strict reading or interpretation of the 3 clauses as to why bail should not be given or why bail should be disallowed. And most of these judgments you will read and see that it is because that there's no material available with the court. When I'm saying the court, it's the High Court, as to why a child who's in conflict with the law should be denied bail. There's nothing to show that he will go back and come into association with any known criminal, or that he will be exposed to moral, physical, and psychological danger, and release would be defeat the ends of justice. Now, one thing which I would like to point out to you is, which is what my law researcher told me, when he was visiting as a student, he went to Delhi along with the others, and there was this young boy who was involved in the Nirbhaya's case. And he said they were told that he's like a nameless child kept there because of the danger to his own life. So very often, if the crime is of such consequence that if a child is released and sent out to face the world on bail, there might be a threat to his own life. In such a situation, he can be kept in custody. So it is twofold, two divergent views coming forth. Gravity and heinousness of the crime is looked at while denying bail, whereas Delhi hasn't been considering that, and our own High Court is much more liberal in allowing bail to a child in conflict with law. Now, what is the next question that would arise is the question of regular bail. Is the question of bail to be dealt under CRPC 439 or under Section 12 of the JJ Act. And in my mind and in opinion, since the JJ Act Section 12 is composite, absolutely composite, because the wording again used in the JJ Act is, if I can read it for you once again, Section 4 for you to read again, and Section 12, which says notwithstanding anything what the CRPC says, bail shall be allowed under Section 12. And of course, there are judgments to this effect. And I would urge all of you to read other than my judgment, is a judgment that has come from the Delhi High Court in this matter, which I will just give the citation to you because we are going to be running short of time. Go through it. It answers a lot of questions. It is CCL Delhi versus, just a minute. It is CCL Delhi versus citation I'm trying to get hold of. I'll pass the citation on in a minute. That has dealt with issues regarding anticipatory bail, Section 12, in a fairly comprehensive matter, and it makes interesting reading for all persons concerned. The other question that was put forth was as to whether a person who is charged under section of the NDPS Act are to be allowed bail or not. And to my mind, the answer would be that there are two special acts, the NDPS Act and the JJ Act. And once the JJ Act is later in time, that is of the year 2015, automatically the child would be entitled to bail under the NDPS Act. And for that, our High Court itself has gone into this question of whether he would be entitled to bail or not. And for ready reference, you can have a look at the judgments of Gurbaz Singh alias Baja, reported as, I don't have the citation of the book, but you'll find it on Law Finder Doc ID 129203. A later judgment by Justice Tyagi, a recent one, Harpreet Singh alias Happy versus State of Punjab, which again goes into the question of Section 12, that once a child in conflict with law is charged with an offense, be it under the NDPS Act or any other act, he would be entitled to bail. The most comprehensive judgment in the recent past has come from the Orissa High Court. No, sorry, from the High Court at Patna. Please take down the citation because this makes very good reading and has dealt with the issues on all levels. It is Amanul Haq Male versus the Union of India through the Directorate of Revenue Intelligence. By and large, Rajasthan High Court, which is also fairly progressive in their judgments pertaining to under the JJ Act, as far as allowing bail to CCLs involved under the NDPS Act, it has been held that the JJ Act is much later in time, and therefore the rigors of Section 37 of the NDPS Act would not be applicable. And finally, of course, there was a question that was posed under Section 167(2) CRPC, whether a child in conflict with law would be entitled to default bail if bail under Section 12 stands rejected. I haven't been able to find anything very much on this, But in my opinion, why not? If you were to read all of the judgments that have come forth from the Supreme Court on a default bail under Section 167(2) CRPC, the primary thrust is that it is a fundamental right under Section 21. Once it has been held to be a fundamental right, why wouldn't a child in conflict with law, even though CRPC is not applicable to it, be entitled to default bail? There's a passing reference regarding default bail with the judgment of Bholu Master versus State of Haryana, where Justice Daya Chaudhary at that point in time dealing with the question of whether bail should be allowed to the child or not. And one of the issues raised there was asking for default bail. And she said, and it had been said in a passing it's a passing reference, that the question of bail would be considered if the challan hadn't been presented in time. If the challan is not presented in time, the bail would be considered. But in the matter of Bholu, the challan had already been presented before he filed for bail. So with that, I can wrap up and say that to me, and in my opinion, Section 12 is a composite section. The JJ Act is a beneficial legislation. And the trend these days, whether a bail should be allowed as defeats under not allow bail to a child for a heinous crime, as followed by Allahabad and Madhya Pradesh, is that that gravity of the situation has to be looked into, as has been done in the matter of Bholu. So with that, I can wrap up and say it's been a pleasure to be here with all of you. Thank you. Is anyone stepping in?
Thank you.
I may take over, Lordship, with your permission, because
yeah, yes. Why not? You please go ahead. Go ahead, please.
I thank Lordship, first of all, for this brainstorming session on the concept of bail, which is a very vital provision in the Act to secure the best interest of the child. Lordship has been very rightly said that Section 12 is a composite provision, and it is linked up not only with the object of the Act, which is to secure the best interest of the child, as well as to the other provision, because if the bail is to be denied, it is only for the purpose of providing correctional services to the child who has come in conflict with law, so that he is able to reform himself during the time he is kept in custody. Because this Section 12 is interlinked with Section 20 of the Act, which provides the second safety valve for a child who has come in conflict with law, that if he is able to reform himself by the age of 21 years, he need not undergo the remaining part of the sentence and is allowed to move out in the society. So I'll just take up the matter ahead from where the Lordship left. Now, so far as the children court are concerned, the children court comes in picture only at the second stage. So once the transfer proceedings under Section 15 of the Act relating to preliminary assessment is done by the JJ board, only then the matter gets transferred to the children court. So therefore, the first responder in case of CCL is the board itself. Now, when this act was enacted in 2015, by segregating the offences into heinous, serious and petty, one would say that the legislature has introduced a bull in a china shop. So it is going to do damage this way or that way. Nevertheless, the Act needs to be made functional, keeping in view not only the overarching principles stipulated in Section 3 of the Act, but also the object of the Act, which appears in the long title itself. Nowhere it says that the primary object of this legislation is to punish the children who have come in conflict with law. The only change which this Act wanted to achieve was to impose greater responsibility upon the children in the age bracket of 16 to 18 years committing heinous offences, so as to motivate them to reform themselves, so that if they want to achieve their freedom after they attain the age of 21 years, they have the motivation to adopt the correctional behavior by the services which are to be rendered by the various stakeholders during the course of his being lodged in various child care institutions. Now, the first step when the children court is seized of the matter is to conduct reassessment. What my in the second session, Madam Pannu was saying, the fresh preliminary assessment. So I'm saying it is reassessment, meaning the same thing. So the first step which the children court is required to do is to make the reassessment once the case gets transferred to the children court. Now here, since under section 101 of the Act, there is a provision for filing the appeal against the order of the board making the preliminary assessment. Under the rules, it is provided that if there is a appeal also, then the children court is required to first dispose of the appeal. The objective behind this is to avoid any conflict of decision. So the safer mode, to my mind, is as and when the matter gets transferred to the children court must elicit from the juvenile or from the child in conflict with law whether he is going to file any appeal or has he filed any appeal, because there is a time limit of 30 days available with the parties to prefer an appeal. So once this is elicited and he says that yes, he is about to file the appeal or he has already filed the appeal, then the appeal should be disposed of first. There is another point that where the appeal is pending regarding the question of determining the age of the child in conflict with law, then that appeal is also required to be disposed of first before reassessment is taken. Assume we can take one situation. Suppose the board concludes that his age is between 16 to 18 years. The child challenges this order before the children court, and the children court concludes that no, he is less than 16 years. So the moment his appeal is allowed, automatically the things will go back to the board. There was another concern shown by a certain children court that where the reassessment is done, are they going to evaluate the same very material which was there before the board, or are they entitled to call for the fresh material or fresh reports of the expert if so required? So the answer is yes. While conducting the reassessment, and it is provided in the provision itself dealing with the appeal, that at the time of dealing with the appeal, the children court is empowered to call for the fresh reports of the expert, because ultimately the whole idea is that the decision maker, be it the children court or the board, is able to make the correct evaluation of all the three factors which are stipulated in section 15. Now, why this is important? It is important because the conclusion against the child would expose him to the peril of being tried as an adult and punished accordingly. So therefore, an extra care should be taken by the children court while making the reassessment or while adjudicating upon the appeals filed by the CCL in this regard. Next important point is that whether the children court is required to interact with the child, because in case of reassessment, obviously there has to be re-evaluation on the part of the children court, which is obviously being headed by a senior judicial officer vis-a-vis the board, which is being headed by the judicial magistrate. Now, while making the re-evaluation in all the three factors, if the children court finds any deficiency, it can call for the additional material. Because reason is, there should not be any prejudice to the right of the child to be treated and tried as a child and not get exposed to the peril of being tried as an adult. So it can interact with the child, elicit the circumstances, it can call for additional reports also from the various stakeholders, including probation officers, the child welfare police officers, so that they have the entire material before them and their hands are not tied and they don't feel that the material on record is deficient for making the evaluation or the correct evaluation of all the three factors which are there in section 15 of the Act. Now, having said this, if the children court comes to the conclusion that this child should be treated and tried as a child, then the proceedings in any case are to be retained by the children court. In no case the proceedings are to be remanded to the board. Now I can only envisage one situation where the matter can go back to the board. Now, for making the evaluation or for entering into the inquiry under section 15 of the Act, there are two foundational facts which must be satisfied before the board enters that inquiry. Now, one is it must be shown on record with whatever evidence that the child ranges between the age bracket of 16 to 18 years. The second is that he is accused of committing the heinous offense. Now, so far as the commission of heinous offense is concerned, it is more a legal question, and one can find out, depending upon the punishment, whether the minimum punishment prescribed is 7 years or more, then obviously it is to be treated as a heinous offense. But so far as the first parameter is concerned, it's a question of fact which needs adjudication, proper adjudication at the hands of the board. So if any of these foundational fact is missing, in that eventuality, the proceedings would be remanded back to the JJ board for proceeding as per section 17 and 18 of the Act. Now, the legislature, while formulating this criteria of segregating the offences and providing a different procedure for heinous offences after adjudicating upon the preliminary assessment regarding the various factors, it has taken extra care that the such children who are tried as an adult and punished also, they are not totally forsaken. The law and the society does not lose hope on such children. I've already stated that the long title of the Act is clear. You will not find anywhere in the long title of the Act the word punishment. So the punishment, according to the gravity of the offence, is not the purpose and object in formulating this Act. This Act, no doubt, in 2015 has made some changes, but the theme of the Act remains the same, just like its precursor Act of 2000. Now, another important aspect while before the children court is there is no automatic transfer of child once he completes the age of 21 years to the jail. This is a second inbuilt mechanism and safety provision provided by the legislature to motivate the child to reform himself. And if he reform himself, he should be let off in the society so that he can be restored and rehabilitated back to the society. Now, in the first lecture, I was referring to section 14 and emphasizing the importance of the time schedule and time limit within which the various inquiries stipulated in the Act should be completed. Now, that was for a particular reason. The reason is, now, as of now, if we examine the scheme of the Act in whole, what is there? Now, suppose a child who has come in conflict with law and is accused of committing a heinous offense is transferred to the children court. Now, their children court tries this child and also sentenced him. Let us suppose he is tried for the offense under section 376 or 302 and is sentenced to life, or let us say a period of 20 years. Now, till the age of 21 years, the Act says that he shall be kept at the place of safety, where obviously the correctional services are to be provided. While disposing of the matter, the children court is obligated to frame the individual child care plan and decide upon the various correctional facilities which can be provided to this child. Now, suppose at the age of 19 or 20, the children court has passed the final order. Then there has to be a periodical review whether he is getting the proper correctional services in the place of safety. For this matter, the child is also required to be produced before the children court, who is to interact with the child and oversee the development regarding these correctional facilities. Now, on attaining the age of 21 years, before he is transferred to jail, the children court is required to make a reformational evaluation order, which is there in section 20 of the Act. Now, in this section 20, if we read the provision, it clearly stipulates the factor to be taken into consideration. So primarily, what has to be seen? First, whether the child has reformed himself. For this, the reports of the expert are one of the critical material which would be available before the board. Second, the board, while periodical interaction, would also be able to assess the progress made by the child in the place of safety. Third, then it has to conclude whether he can be a contributing member to the society. So once after making this entire evaluation, which I say that is a reformation evaluation by the children court, it has to decide. And this is a very critical decision so far as the child in conflict with law is concerned, whether he should be released on attaining the age of 21 years or he should be transferred to the jail to suffer the remaining part of the sentence. So therefore, from the standpoint of the child in conflict with law, you can very well assess that how sensitive and critical this second stage, that is section 20 reformation evaluation order is. So how is connecting with section 14 of the Act? That because as of now, the constitutional courts have not come across the cases where they have to decide that if there is a violation of this section 20 right of the child in conflict with law, what would be its effect? Whether it is going to violate his fundamental right under Article 20, that he lost the chance to reform himself, and he was straightway transferred to the jail. Now, if the inquiries are delayed at the initial stage, let us say for 1 year, 2 years, because we are coming across cases where the board kept on sitting on the matter for well enough 2 to 3 years, and at a later stage certainly made the evaluation under section 15 and transferred the child to the children court. Now suppose by that time he is already about to attain the age of 21 years. So he will miss this reformation evaluation, and that would be, I would say, not only detrimental but suicidal for him, because he will have to suffer the entire sentence in jail if he is ultimately imparted sentence by the children court. So this is how all the beats or different provisions of the act are to be connected together to form a garland. Like we connect the beads and we form a garland. Similarly, if all the provisions are connected together, we will be able to notice that how one provision will have repercussions at the next stage of the adjudicatory processes. So I'll also highlight, because I've got 2-3 minutes left, I will not exceed the session, one or two gray areas which ultimately the Constitutional Court will require to answer at one point or the other point. One is that where, because of the fault of the court or the board, the case of the child in conflict with law is not concluded before he attains the 21 years of age. So question would be, if he miss on section 20 reformational evaluation order, what will be the effect of that on the trial? Will the sentence be still kept intact? Will the child be still forced to undergo the remaining part of the sentence, or the children court can still make the evaluation irrespective of the fact, taking into consideration the correctional services and reformation process which the child has undergone during the period he was lodged in child care institution till he attained the age of 21 years, irrespective of the fact that this inquiry concluded at that age. Second is that suppose the children court is unable to conclude the inquiry till he attains the age of 21 years, should he be automatically transferred to the jail, irrespective of the fact that we have section 12, which relates to the grant of mandatory bail? That is one. And second, how the reformation evaluation would be made in that situation, where he being on bail and his inquiry is being concluded after he attains the age of 21 years. And third, which is in relation to section 6 of the act, which is a deeming provision, that where the person is apprehended after he has crossed the age of 18 years. Suppose he is apprehended at the age of 25, 28, 30, and now he is being put up before the board. So one aspect would be whether the board would be competent or would be able to still make the evaluation in respect of such an individual. And second, what about the reformation evaluation order under section 20, because he's definitely going to miss the timeline. He has already crossed the age of 21 years. So therefore, these are certain gray areas in the act which we all will encounter while implementing the act. Nevertheless, in order to make it more functional, if we see the scheme of the entire act, we will notice that in the ideal situation, these gray areas would not crop up. But in the non-ideal situation, definitely we are going to face these difficulties, which to my mind would at some point of time would require adjudication at the hand of the Constitutional Court. So I thank all of you to be in this workshop, and I thank the Judicial Academy also for providing me this opportunity to create few sessions and share my views on the act. Now there are definitely this jurisprudence in this area is evolving, as Lordship in the previous session has been highlighting, that in various aspects we are finding conflicting position being taken by different high courts and even in the same high court itself. But nevertheless, in this evolving jurisprudence, we all are going to learn and try to improve, keeping in view the overarching principle of the act and the aim and object of the act, which was envisioned by the legislature at the time of its enactment. So thank you so much. Over to Dr. Balram Gupta to take over the session. if sir, you can give me 5 minutes more, then I would like to clarify certain queries of the JJ board which I missed in my first session. So I leave it to you. If you allow me, then I'll take it. Otherwise, so I'll just, since Dr. Balam Gupta has not chipped in, so I would like to play that PPT and clarify those doubts which certain JJ board members raised during the interaction. First was regarding termination of inquiries in respect of petty offences. Probably the provision itself is clear. It gets terminated automatically, so therefore there should not be any hitch in doing so. Next was for preparing individual care plan, whether to be prepared pending inquiry or on disposition. Now on disposition it is mandatory. Pending inquiry it is optional. So if the child requires correctional services at the very initial stage, so there should be intervention by the board by providing the individual care plan as well as the other correctional services. So whether it is to be prepared after he crossed the age of 21 years, probably to my mind, then it is not required, because by that time the reformation evaluation order is already made. So the follow-up steps, if the final report is not filed, the board should not feel handicapped so far as the powers are concerned. I have already said in the first session that there are immense powers available with the board, and it can exercise all the powers available to the JMIC under CRPC. They can call for the final report, they can initiate or recommend the action against the child welfare police officers if the final reports are not coming on time, interaction with the child, and kind of questions. So all kind of questions can be asked, but this interaction has to be kept confidential. In Madhya Pradesh, when I interacted with one officer, she has been preparing questionnaire at the time of interaction and then putting it in a sealed cover, not to be used while adjudicating the liability of the child in conflict with law, but definitely for deciding the correctional services as well as for making the preliminary assessment under section 15 of the Act. Then right of the lawyer to examine, probably Madam Mandeep Pannu already cleared this part. So absence of child during inquiries, there is a detailed procedure which is to be adopted. Then on attaining majority, if he attains majority and commits an offence. Now this question is simple, that if on attaining majority he commits another offence, then for that obviously he will be treated as an adult and dealt with accordingly. NDPS cases, if only the child is involved in the NDPS case, then the inventory can be prepared by the board under section 52A of the CRP of the Act, because powers of JMIC are already conferred upon the board. So therefore, where only juvenile is being put up for trial under the NDPS case, then obviously the child is to be produced before the JJ board, and inventory can also be prepared by the board. Now, when the principal magistrate is on leave, then the Act says that the child will be produced before any member of the board, but not before the regular courts. Monthly roster is required to be prepared by the principal magistrate. So final report, delaying the conduct of preliminary assessment, Madam Mandeep Pannu has already dealt with. Non-appearance of witnesses, I have already said that they can take the coercive measures under CRPC for getting the witnesses to appear before the board. Then section 12 is already clarified by my lord, that it is equally applicable to the children court. Then joint proceedings I have already clarified. Probably the remaining part is already covered in the sessions which have been done prior to mine. So Dr. Balam Gupta, may please take over. Dr. Gupta.